I know a lot of us have seen, maybe in the hard way of seeing things happen, is that when you make a legal mistake, it
Hmm.
really bites you. Where it's
Absolutely.
too late to fix
Mhm.
things, or it gets really costly.
So today we're bringing in Jeff Barnett and Keith Ludy of Barnett and Ludy Law Firm. Thanks so much for being here. And we're going to talk about the biggest legal mistakes that people make when it comes to estate planning. And I think one of the things that we see pretty often is people who will ask the question, hey, mom's got dementia, she's 80, and we don't have a will. What should we do? And there is a point at which it's too late to take action.
Yeah, absolutely. One of the biggest problems that people have is that they just wait too late. And it doesn't have to be obviously, the example that you gave. That's a great one. And it
Mhm.
happens all the time for sure. But people always think they've got more time. And we make this point a lot to everyone that we talk to, whether it's at seminars or in social media or whatever. Nobody knows what tomorrow will bring. Nobody knows if tomorrow is your last day. And if tomorrow is your last day, you need to be ready,
Mhm.
regardless of whether you're 25 or 35 or 85. Tomorrow, you need to have your documents in line. And so it's very important not to wait.
When is the right time to make a will in particular? And I tell them, well, I have two answers. One is yesterday, and the next one is if you can tell me the date that you're going to die, we'll back it up at least 2 weeks so that we have time to draft and you have time to sign. Everybody is, whether they want to realize it or not, everybody's on a road, and that road is headed toward a cliff. And if you're not prepared for that, you're in for quite a shock. Usually, when people come in, the first thing we talk about is what legal documents do you already have in place. And by getting at least your basic legal documents done, you can kind of pave the road a little bit, get rid of those potholes and those unexpected twists and turns, so that whatever happens, it should be a lot smoother for both you and your loved ones.
Yeah. Am I right in saying that there's basically nothing you can do too early? Because there may be something where I get more money, or I have
And you may
more
have to
property
update it.
where I have to update it. But
Right.
otherwise, go ahead and get it done.
Oh,
That,
absolutely. As far as the basic five documents that we've talked about a lot, there's absolutely no time that's too early. Well, other than before 18, you couldn't do it before
yeah.
you're 18. There's not a problem having it that early because you can still benefit if something happens to you medically, or something happens to you financially or whatever, and you end up with some money. If you've already got the documents in place, you're already set.
Right.
But the biggest problem is that you have probate, you have adult children who may not be able to make decisions and help their parent if you don't have. And maybe let's just go over real quick those, just the mention of what those five legal documents are, starting through will, powers of attorney.
Yeah. It's the basic five are the will, the medical power of attorney, the durable power of attorney, which is for financial, property, legal matters, all those kinds of things, and then a directive to physicians, which is also commonly known as a living will or an advance directive, and then the last one is an appointment of agent to control disposition of bodily remains.
Okay, gotcha. And you brought up the point about, somebody who maybe doesn't think they have that much money, or much to give or leave behind, if you will. And potentially even maybe you have a couple who thinks, well, even if we have a lot of money, it's just going to go straight to my husband. So is that often a mistake that people make, thinking that I don't really need a will because it's just going to go straight to my heirs?
Yeah, that belief is one of those that falls under the category of true but not accurate. A lot of things, a lot of times people do have things set up that are what we call pre-probate, like money in a bank account, and they have named beneficiaries. There's a lot of ways that you can make mistakes or think you have one thing when in fact you don't. A will is at least a safety net. You never know until somebody passes away and we sit down and evaluate their estate whether or not they really need to go through probate. And there's a huge, huge difference between going through with a will and going through without. If you go through with a properly drafted will, then there's predictability usually as far as time, cost, and outcome. If you have to go in the probate court and you don't have a properly drafted will, you lose all that predictability and for those three things.
Kim and I love to tell the story that we didn't have wills for each other until we were about 30, when our first child was born. And even then, we did a floppy disk will. And when you do a do-it-yourself type of will or power of attorney, it can get you in trouble. Is that correct?
Yeah, we see quite a bit of that, and that question comes up a lot with everybody wants to do it yourself. And the thing is, if you don't know what you're doing, you're gonna wind up making mistakes. I've looked at some of the documents that have come off the do-it-yourself websites and all of that, and first of all, they tend to not be state specific. They tend to be very generic for a nationwide audience. And so, even if you were able to maneuver all the way through and make the right choices, as far as what's in your document, you may still wind up in probate court having to jump through extra hoops, which translated means more time and more money to try to fit a square peg into a round hole. The bigger problem, though, is that if you don't have a background of knowing not only what should be in the document, but what shouldn't be in the document, you can create a lot of problems for yourself that would not have been there if you had somebody drafting it who knew what they were doing. It's a little bit like auto mechanics, you know. I mean, anybody can take a wrench and start unscrewing and screwing things in, but to get the desired outcome, you really need to have somebody who does this for a living so that you can have that predictability that we talked about.
The two most expensive, most complicated, and longest probates I have ever had to handle for a client resulted from DIY. The situation in both cases was that the person either did it themselves or a non-lawyer family member helped them put it together. One of them was a form. One of them could have been a form, but it was typewritten, and it was in both cases. They were missing critical information, probably because the form that they had either didn't have it in the first place and they didn't know to add it, or it was there and they said, "Yeah, I don't think I need this," and they deleted the paragraph, and that was the most important paragraph, or so there is absolutely, and in both situations, what ended up happening is instead of it being a super smooth, easy, straight path, well paved, like Keith talks about, when you've got a well-written, well-drafted Texas will, or the other case scenario where you don't have a will at all, they end up having to go through both. They had to go through two parallel tracks of probate and pay for both of them because it was a lot of extra work. It was basically all of the work of a will probate and all of the work of an heirship determination with administration, all happening simultaneously, and it was more expensive and more lengthy and more complicated. So DIY is absolutely the worst way to go.
Well, and so what if I want to maybe I want to take a stab at it, if you will, to save a little money and start with the DIY and have an attorney look at it?
Mm-hmm. Yeah, that question comes up quite a bit as well. People think that they're going to be saving money by doing that. It's quite the opposite. If you go to an attorney and we run it through, most attorneys have pretty sophisticated software that not only is updated every time that the legislature may update something, but we can run stuff through our software and we know what comes out on the other end is going to be acceptable because we've tested it. If somebody brings us a document that they have drafted somewhere else and says, "Here, go through this point by point by point," that's going to take a lot of time to sit there and mark through. It's going to take twice the time. We're probably going to bill by the hour, and you're going to wind up paying more. And there opens up the possibility, just human error. I mean, we could go through it point by point, but people do miss things or say, "Well, that's close enough," or whatever. And then it turns out that when a judge looks at it years later, they go, "No, that's not good enough." So, trying to do the comparison and can you mold this lump of clay that I brought you into something? It's just easier for us to start at the beginning and run it through our mechanics of doing it.
And it's not just that, but if they've brought us something that really does need to be redone, then basically then they've paid someone for a form or paid some website for a form, and then they've paid for our review, and then they're going to end up having to pay us for documents either to be completely overhauled or better yet, just done with our professional software and with our professional edits. So it's a lot, it's a lot more. It ends up being a lot more expensive and a lot more complicated.
And what's a holographic will?
A holographic will is basically a will that means it's written all in your own handwriting.
Got it.
It is not a will that you decide to draft yourself and you type up and then sign. That's not a holographic will. Holographic will, it means that it is completely top to bottom in your own handwriting,
Okay.
and it has the same pitfalls of any kind of form or any kind of situation where somebody is drafting who is not an attorney. They
Right.
don't know what to add, they don't know what not to have in there, and they end up with a document that that could very well be the worst of all
Right.
scenarios.
Right.
And
the possi-
holographic will, the idea is sort of what I always had picture in my mind is the person who's trapped on the desert island, like Tom Hanks, and they hoping someone finds them at some point, and so they find a leaf or something, and they're scribbling, in on the leaf, just trying to say, hey, leave all my estate to my wife or something like that. It doesn't have any complexities, and you actually wind up having to jump through a lot of hoops to get that through the probate court.
Yeah.
Yeah, absolutely. It's absolutely the worst case, of doing it. If you literally are about to die and you've got nothing but a piece of paper and a pencil or a pen, I mean,
Better
you know,
than
it-
nothing potentially.
it potentially is better than
Fair.
literally nothing, but depending on how much you write and how much you include or don't include, it could be more complicated. But it still is something. It still is, at least it's an expression of your wishes.
Yeah.
That as long as your handwriting can be proven, then it at least could end up with the result you want. It may just be more complicated to get there.
And you kind of mentioned this a little bit before, but also is another big mistake that people sort of just crowdsource information or, ask their friends who are not attorneys, hey, what do you think? Or is this good enough or that kind of thing?
A little bit. I can't speak for Jeff. I don't see that quite as much.
Okay.
The people walking next door and trying to get legal advice from their neighbor who, is not an attorney, but
Or
you do-
somebody on the PAP website, PAP Facebook,
Right.
saying, you don't need that.
Yeah.
Right. Yeah. You got to make sure that you are talking to.
Make sure you're talking to an
where-
expert.
Right. Where you're getting the right
Sure.
information.
Yeah.
And then can there be mistakes? I guess there can be mistakes made in any scenario, even just with the choices that are made, but especially when it comes to powers of attorney, as far as having or too many, what are the biggest mistakes made with powers of attorney?
Yeah, people come in from time to time and they'll say, hey, I want to name somebody to be my co-agent. I've got 2 kids. I want to be co-agents. And what I tell them is this: if you needed a ride to the store, would you ask both of your children simultaneously to drive you? It's like, okay, you do the steering wheel and you do the pedals. That's going to create an accident. You're going to crash and you're going to wish you hadn't made that choice. You want to choose one person. Usually, if people think about it, they can think of the person that they trust the most in this world, and then name the others as backup just in case something happens to their original choice. The idea of co-agents is just a handful of times that I've done it because the client said, look, you don't understand our family dynamics. People are going to have their feelings hurt. Most of the time we could talk them out of that. Occasionally I've threatened to get up on the table and stomp my feet. Never actually come to that though.
Oh, thank goodness.
But certainly just something to consider and to talk to your attorney about, that if you are for some reason really adamant about that, understanding what the implications are,
Yeah.
because with co's, then both whoever are the co's have to be, or if you have 2 or 3, or it could get really complicated because everybody has to be in place in person to be able to make decisions. Is that correct? I mean, depending
Maybe.
on medical
Well,
or
it depends on how it's written. If you have co and they all have they all have to sign equally, then now you're having to round up a whole bunch of signatures and get everybody to agree. I think that even the worst case, and usually you might see that if you do have, siblings or something who get along really well and kind of have the same vision. But the one that bothers me the most is when they come in and they say, I've got 3 kids and they're co-agents and they can all act independently of each other with one signature. Now you've got, sibling number 1 does something, sibling number 2 finds out and says, no, I don't like that. And so they go back and undo it. Now sibling 3 sneaks in and they do something completely different. I mean, it's like watching the 3 Stooges,
right.
Trying to figure something out.
Right.
Yeah.
And I would imagine too, proximity makes a difference depending on where your kids are located and where you are, as far as, what makes most sense.
Yeah.
but something
To some
doctors
degree,
think
I mean,
about.
there's no legal difference in the sense that obviously, somebody even from, who lives in, India or in England or China, could be an agent for somebody. It's just a little bit harder.
Yeah.
Okay.
So if you've got two people of equal, that you trust equally or that you trust close to each other, then proximity would be a definite way to decide between the two. But if
Okay.
clearly the best person is someone who happens to live hundreds of miles away or whatever, then you should pick the best person, because these days,
Got it.
things can be done by video conference, things can
That's
be
right.
done by DocuSign,
Yeah.
things can be done remotely in various different ways.
A
Gotcha.
new world.
Yeah,
Any other
absolutely.
mistakes that we're missing that we need to let people know about?
Well, don't be penny wise and pound foolish. That goes into the whole, DIY or uh, you know, you using a non-lawyer to get advice from or whatever. Whether it's somebody in a chat room or whether
Yeah.
it's something else. Just it is almost always less expensive and a way better outcome, that also results in less expense to go through a qualified attorney. And that's true whether you're in Texas or California or Washington or whatever. Just get an attorney and get it done. It's an investment that is well worth it.
And I would also say, make sure that whatever attorney that you go to, that you spend the time, don't be in a rush. If they're talking to you, the beginning of the meeting is probably going to be them getting information from you to get a picture of your situation. And when they start recommending, well, I think this might be a good choice for you, this might be, make sure that you ask the question so that you understand what documents do, how they work when you decide if that one is for you. It always makes me nervous when people come in. Jeff and I like to spend a lot of time with our clients explaining the documents, even on the day that they come in and sign, even if we've had the previous discussion, to walk them through and show, now this is the section that does this and this does this. I think sometimes people are just in a hurry to get things done, and they don't really want to stop and read, but a lot of these things you have to understand how they work.
Yeah.
Like, for example, with a springing durable power of attorney, person signs it naming their financial power of attorney, but that doesn't actually activate unless or until a doctor signs off and says a person is not capable of managing their finances anymore. It's like a light bulb and nobody's flipped on the switch. And there are people out there trying to act with a durable power of attorney that has not been activated yet.
Right.
Yeah.
Right. Yeah, we see that, and that can make things really complicated. Yeah.
Yeah.
All right.
Yeah. Jeff Barnett, Keith Ludy, great advice as always. Thanks so much.
Thank
Our
you.
pleasure.
Thank you for having us.
I think, as always, what we've learned here is that you've got to trust the experts. In this
Right.
case, the attorneys. They know what they're doing, and if you don't, it's really going to make things a mess.
And do it before you need it, because then if you wait too long, it's too late.
Exactly. Hey, if you have any other topics you'd like us to discuss, please let us know. Parenting aging parents.